Suppose you purchased a property through a registered sale deed, and after a few years someone suddenly claims that the sale deed is illegal. Or imagine a situation where a seller tries to cancel the sale deed after receiving the full payment. A serious legal question arises. Can a registered sale deed really be cancelled? Many people believe that once a document is registered in the sub-registrar's office, the transaction becomes final forever. But the Supreme Court of India has clarified that a registered sale deed can be challenged and even cancelled in certain circumstances. Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. I have a humble request to you. You can join this channel by clicking on the Join button given below this video. Additionally, you can scan the GPay QR code shown here and contribute a small amount of 59 rupees or 119 rupees as per your wish through any UPI app. Your small support will further strengthen my efforts to spread legal awareness among citizens and to provide correct legal information to the common people. So, let's move ahead now. In this video, we will understand whether a registered sale deed can be cancelled, when such cancellation is legally possible, who has the authority to cancel it, and the important Supreme Court judgments governing this issue. Property disputes are among the most common civil disputes in India. A large number of these disputes arise after the execution of sale deeds. People often assume that registration of a sale deed gives permanent and unquestionable title to the buyer. However, Indian law recognizes that a registered document may still be challenged if it was executed illegally, fraudulently, or without lawful authority. To understand this issue properly, we must first examine the legal nature of a sale deed. Legal nature of a sale deed. The concept of sale of immovable property is defined in Section 54 of the Transfer of Property Act, 1882. According to this provision, a sale is the transfer of ownership in exchange for a price paid or promised. The section further states that in the case of tangible immovable property valued at more than 100 rupees, the transfer can be made only through a registered instrument. The process of registration is governed by the Registration Act, 1908. Registration serves several purposes. It creates a public record of the transaction, ensures authenticity of the document, and provides legal evidence of ownership. Once a sale deed is validly executed and registered, ownership generally passes to the buyer. However, the law also recognizes that registration does not automatically validate a transaction that is illegal or fraudulent. Can a registered sale deed be cancelled? The Supreme Court of India has clearly held that a registered sale deed cannot be cancelled unilaterally by the seller or by the sub-registrar. The leading judgment on this issue is Thota Ganga Laxmi vs. Government of Andhra Pradesh. Citation: 2010, 15 SCC 207. Bench Justice Markandeya Katju and Justice T.S. Thakur. Date of judgment 7th July 2010. In this case, certain individuals executed a unilateral cancellation deed before the sub-registrar seeking to cancel an earlier registered sale deed. The sub-registrar accepted and registered the cancellation document. The Supreme Court held that such unilateral cancellation is completely illegal. The court observed that once a sale deed is executed and registered, the seller loses title to the property and cannot cancel the transaction on his own. If the seller believes that the sale deed was executed due to fraud, misrepresentation, or any other legal defect, the proper remedy is to approach a civil court and seek cancellation of the document. Legal remedy for cancellation of sale deed. The statutory provision that allows cancellation of written instruments is Section 31 of the Specific Relief Act, 1963. Under this provision, any person against whom a written instrument is void or voidable may file a civil suit requesting the court to cancel the document if its existence may cause serious injury. If the court is satisfied that the instrument is invalid, it may declare the document void and order that it be cancelled. Thus, the cancellation of a registered sale deed is essentially a judicial process and can only be done through a court decree. Sale deed obtained through fraud. One of the most common grounds for cancellation is fraud. The Supreme Court explained this principle in Prem Singh vs. Birbal. Citation 2006, 5 SCC 353. Bench Justice S.B. Sinha and Justice Markandeya Kadju. Date of judgment 7th April 2006. In this case, the court emphasized that fraud vitiates all transactions. A document obtained through fraud can be challenged and declared void. The court further clarified that if a document is voidable, it must be challenged within the limitation period. A void document need not be cancelled, but courts may still declare it invalid for clarity. Therefore, if a sale deed was obtained through deception, misrepresentation, or concealment of material facts, the court may cancel it. Lack of free consent. Another ground for cancellation arises when the document is executed without free consent. The concept of free consent is explained in Section 14 of the Indian Contract Act, 1872. Consent is considered free only when it is not caused by coercion, undue influence, fraud, misrepresentation. If a person signs a sale deed under pressure, threats, or undue influence, the transaction becomes voidable and may be set aside by the court. Seller had no valid title. A sale deed can also be challenged if the seller had no legal ownership of the property. The Supreme Court discussed this issue in Suraj Lamp and Industries Pvt Ltd vs. State of Haryana. Citation 2012, 1 SCC 656. Bench Justice R.V. Ravindran and Justice A.K. Patnaik. Date of judgment 11th October 2011. The court examined the widespread practice of transferring property through general power of attorney (GPA) transactions instead of proper sale deeds. The Supreme Court clarified that legal ownership of immovable property can be transferred only through a valid registered sale deed. Transactions based merely on power of attorney or similar arrangements do not convey ownership. If the seller himself does not possess valid title, the transaction can be challenged and declared invalid. Registrar has no power to cancel registered document. The authority of the registrar after registration was discussed in Satyapal Anand vs. State of Madhya Pradesh. Citation 2016, 10 SCC 767. Bench Justice A.M. Khanvilkar and Justice D.Y. Chandrachud. Date of judgment 8 September 2016. The Supreme Court held that once a document is registered, the registrar becomes functus officio, meaning that he has completed his statutory duty. The registrar has no authority to cancel or revoke the registered document. If any dispute arises regarding the validity of the transaction, the parties must approach the civil court for appropriate relief. Limitation for challenging sale deed. The time limit for seeking cancellation of a document is governed by Article 59 of the Limitation Act, 1963. The limitation period is 3 years from the date when the plaintiff first becomes aware of the facts that entitle him to seek cancellation. Therefore, if a person discovers fraud or illegality in a sale deed, he must approach the court within this limitation period. Procedure to cancel a registered sale deed. The process generally begins with filing a civil suit for cancellation of the sale deed before the competent civil court where the property is located. The plaintiff must clearly state the grounds for cancellation and provide evidence such as documents, witness testimony, and supporting material. After examining the evidence and hearing both parties, the court may pass a decree declaring the sale deed void or voidable and order its cancellation. Once such decree is passed, the order is communicated to the registration authorities so that the record can be corrected. Conclusion. To summarize, a registered sale deed is a strong legal document transferring ownership of immovable property. However, it is not immune from legal challenge. A registered sale deed can be cancelled if it was obtained through fraud, coercion, lack of consent, or if the seller had no valid title. But the most important principle established by the Supreme Court is that only a competent civil court has the authority to cancel a registered sale deed. Neither the seller nor the sub-registrar can cancel the document unilaterally. Therefore, if any dispute arises regarding the legality of a property transaction, the correct legal remedy is to approach the civil court and seek judicial determination. Thank you for watching this video. If you found this video useful, please like it, subscribe to the channel, and press the bell icon for more legal information. Jai Hind! Jai Bharat!